Okay, classmates, who can tell me what this is? That's right. It's a very outdated piece of technology, the VHS. However, it wasn't that long ago that we were using this, and then it was replaced by this, the DVD disc. Now, as the general public's access to this technology grew, so did certain questions in regard to copyright issues that this new technology brought. And so in 2001, the Federal Court of Australia looked at these questions in the case of Australian Video Retailers Association Limited and Warner Home Video Proprietary Limited. In this case, the parties went in with 4 questions to be answered, which in turn allowed the court to rule on 4 very important findings. Firstly, that when playing a DVD disc on a computer or DVD player, a person does not make a copy of the whole or a substantial part of the motion picture. There was some concern that due to the necessity of a DVD player or computer to temporarily store data from the DVD in its RAM, that this could amount to a reproduction or copy for the purposes of Section 10 of the Copyright Act. The court held that no, it did not, and the mere fact that over a period of time, that being the time taken to play the motion picture, tiny parts are sequentially stored, does not mean that the motion picture is embodied in such a device. The second holding the court made was that the computer programs that are embodied in the DVD comprise only of the menu that you find at the start of the DVD, and does not contain any of the motion picture itself. This runs into the third holding that entering into a commercial agreement involving the letting for hire of DVD discs, the computer program, the DVD menu, does not constitute the essential object of the hiring. Section 31(1)(d) of the Copyright Act includes the exclusive right to enter into a commercial rental arrangement in respect to those programs, except for where the programs are not the essential object of the rental, under Section 31 subsection 5 of the Act. Now, the court held that the essential object of the rental of a DVD was the video and audio content, the motion picture, not the program which provides for ease of navigation through the menu. Finally, the fourth holding in this case was that, similar to the first holding, that a person who plays a DVD disc does not ordinarily reproduce in a material form the whole or substantial part of the computer program. This again looked at temporary data storage capacities of RAM in a DVD player or computer, and whether this constituted replication in a material form under Section 31, subsection 1AI of the Copyright Act. The court held that in the ordinary course, that is, when a computer has not been modified to collect this data, that it is impossible to reproduce the program, and so, pursuant to Section 10 of the Copyright Act, reproduction is not in a form of storage from which the computer program or a substantial part of the computer program can be reproduced. So to summarize, firstly, the court held that playing a DVD does not equate to making a copy of it. Secondly, that the menu at the start of a DVD, whilst it is a computer program, does not contain any of the audio or visual or movie content. Thirdly, that the essential object in a commercial agreement for the letting of a DVD is the motion picture and not the computer program or the menu. And lastly, that playing a DVD does not reproduce in a material form the computer program. Thank you.